all. Good afternoon. My name is Bo Kong, and I am the ConocoPhillips Petroleum Associate Professor of Chinese and Asian Studies and a co-director of the OU Institute for US-China Issues. Welcome to the Institute's speaker series on STEEP issues, which promote dialogue on security, technology, economic, environmental, public health, and political issues in US-China relations. Before starting today's program, let me first thank my colleagues Zhu Zhang, Stephanie Sager, and Maura McAndrew for providing the logistical assistance that has made this event possible. The 2017 US National Security Strategy defined the bilateral relationship between the United States and China as one of the great power rivalry and frames China as the USA's #1 threat. Given the central role technologies play in shaping China's economic growth, political control, and military modernization at home, as well as export competitiveness and global engagement, it is not an exaggeration to say that one will not be able to understand US-China relations without considering the issue of technology. Indeed, the tech war waged by the Trump administration against China reminds us how prominent the issue has become. However, it is worth noting that just as it can divide the two countries in areas such as cybersecurity and artificial intelligence, technology can also provide a potential catalyst for cooperation in such areas of the global commons as climate change. So how do we analyze the role of technology in shaping US-China relations? One place to start is to look at the issue of intellectual property rights. To help us understand the role of IPR in US-China tech rivalry, I'm delighted and honored to present to you two leading experts. Mark Cohen is a distinguished senior fellow, director, and lecturer of the Asia IP project at the Berkeley Center for Law and Technology at the University of California, Berkeley. He has nearly 40 years of experience on IPR issues in China that spans across the private sector, government, and academia, decorated with many, many awards. It's almost impossible to list all his achievements here. Instead, I will briefly mention some of the highlights of his career, including senior counsel, advisor to the Undersecretary of Commerce and director of the US Patent and Trademark Office, director international intellectual property at Microsoft Corporation, senior attaché at the US Embassy in Beijing. Mr. Cohen holds a JD from Columbia University, an MA from the University of Wisconsin Chinese Language and Literature, and a BA from the State University of New York at Albany in Chinese languages. He co-authored the book entitled Anti-Monopoly Law and Practice in China, co-edited Chinese intellectual property law and practice, and published many articles. In addition to directing the Berkeley Center for Law and Technology, Mr. Cohen also hosts the popular blog ChinaIPR.com and serves as an advisor to the IP database IPhouse.cn. Timothy Hsieh is our discussant, and he's assistant professor of law at the Oklahoma City University School of Law. His research, teaching, and scholarship focuses on intellectual property as well as law and technology, particularly in some of the topics of great interest to our faculty and students here at the College of International Studies, such as computer, internet, and social media law, information technology and privacy law, blockchain and artificial intelligence law. With a BS in electronic engineering and computer science from the University of California, Berkeley, and an MS in electronic engineering from UCLA and a JD from the University of California, Hastings College of the Law, Professor Hsieh worked in both the private and public sectors prior to OKCU and made many achievements that are too long to list here. His publications have appeared in many journals such as IDEA, the IP Law Review, Medium and Entertainment Law Journal, the Washington Journal of Law. In addition, he's also written short fiction and directed short films. Without further ado, please join me in welcoming Mr. Cohen, and then Dr. Hsieh will follow up and provide some comments.
Thank you so much for that great introduction, Professor Cohen. Appreciate it.
Of course.
Okay. Tim, should I start? Oh, you're muted. Okay, that's fine.
Sure. Yeah. I mean, whatever
Okay.
you want.
Okay.
I guess
Okay.
maybe I was just, if you wanted to start with like what you feel is like maybe a overview of the current state of IP
Sure.
laws and IP rights in China, and also one thing I was just sort of thinking about, like I saw in the news, like a lot of these quantum computing advances coming out from China, and you know, as you know, is already like China is already a leader in many spaces, including AI and you know, high-speed
Right.
rails and
Okay.
fintech and
Sure.
semiconductors. So I think it's one of those things where I know we talked about before, where you know something is like already available in China, you know, a couple months or even a year before it comes out in the U.S. and especially you know with companies like Huawei, where they have really dominance of standards like 5G and are working on the next big thing.
Right.
And so I was just
Sure.
curious on your take on all that.
Sure. Let me try to. I'm certainly going to intend on addressing those issues, particularly since we want to talk about technology, kind of the hard IP side of the equation, patents and technical trade secrets, plant varieties, what have you, all of which have a strong technology orientation. I thought it might be good to kind of divide my kind of introductory comments into three baskets, and hopefully those would open up the floor for more discussion and comments by you. One of them is, where is China now on IP? Another one is, does China pose a threat? And a third is, if it does pose a threat, what can we do about it? What should we do about it? And hopefully everybody will have some different views of all three of those issues. Obviously, as Professor Cohen just mentioned, IP has become a very important part of the bilateral relationship, and you know, precipitated bilateral trade war. And actually, it was areas that previously hadn't been that significant, particularly technology transfer, licensing, patents, China's technical emergence, dominance, antitrust. All these things were not really that big a part of the bilateral picture. Certainly when I was attaché in Beijing, the issues back then were pirated music and software and motion pictures and counterfeit luxury goods, trademark issues. Even the internet wasn't much of an issue back then. I remember in 2007, preparing for the Beijing Olympics, I said, you know, to my colleagues in the embassy, we really should focus on the internet. Everybody was concerned about guys selling pirated DVDs. So it's really important to keep in mind that perspectives have changed, and they've changed dramatically. I suspect before Donald Trump, and I remember having these discussions, 2015, 2016, people would still say China can't innovate. It's a communist country. They're too busy knocking people off. Always going to be imitating and not innovate.
Right.
And all of a sudden, I mean, we should be careful when we say it and why we say it. All of a sudden, beginning with Trump, they're out to eat our lunch. You know, they're stealing, and not only that, they're better than us. And by the way, the literature on countries that have prospered, if you will, on knocking off and stealing other countries' technology does not speak well to China's future. Maybe China has a different model. A lot of the literature around East Germany showed that if you were dependent on theft, you're not going to be able to innovate. It actually undercuts your ability to innovate, at least in the long run. So it's just important to keep in mind, there's a high degree of polarization around this discussion. And as I'll do later when we talk about the threat, I think we have to really disaggregate and do the hard work of looking at where China is competitive and why, and what data would support that, and where China may not be competitive, and there may even be a lot of smoke around how badly China is doing. And I'm not going to come up with generals. I'll give you my sense of where things are, but almost every area needs attention and thought. It's really hard, particularly, you know, you mentioned AI. That's a bundle of really important technologies. And you have to really pull it apart. Facial recognition, just to give you a taste, absolutely, China's a leader. Facebook is pulling out of facial recognition. Privacy concerns. But in other areas of AI, like semiconductor technology, graphical processing, we have NVIDIA, we have Intel, we have others. It may be quicker. So really
autonomous vehicles as well, I guess, applications, and
exactly.
NVIDIA has used a lot in self-driving cars.
Right. So it's really important, I think, to, particularly if you're going to take the view of the panda hater and the panda hugger and say China is a threat. Well, let's be careful about where it's a threat. Let's be careful, as Professor just mentioned, where there's a global commons, we really need to collaborate, and where are the competition areas that don't pose the existential threat, and we just have to be worried about our economy. But let's talk a little bit about IP, because I think there's a lot here that.
I just wanted to, I thought that was so interesting. You mentioned how the shift from, China being this copier of technologies, but now very much it's a leader. And just one quick example, when they did rankings of universities, like I'm just taking electrical engineering programs, for example, you'd always see the top US programs like, at MIT, Stanford, Berkeley. But now recently, like if you see those rankings, you see very prominently Chinese universities at the very top. And so it's very much like the technology now has developed to a point where it's even rivaling or even, exceeding the.
Well, certainly the universities, but don't forget, and this is where China is so challenging. Chinese universities are building themselves around the metrics. So
the standards.
Let's say if hypothetically a ranking element is, and I know this is true of faculties, do you have joint programs with foreign law schools? Do you send your students overseas? Do you send faculty overseas? How often are you cited in international publications? So then those are immediately the metric they impose upon the faculty and students. So they're really playing to the metric, which can sometimes distort. It's a fair metric, but sometimes it can distort. So it's important to keep that in mind as well. And we'll come back to that in some of the issues. I think going along with that, in a sense, it's important to keep in mind that I think a distinguishing feature, perhaps the biggest distinguishing feature of China's IP environment, and perhaps its innovation ecosystem, is the significant role played by the state. Now, state certainly plays a role in innovation, including in the U.S. We have DARPA, we have DOD, we have HHS and NIH funding lots of great stuff in the health sciences. So it's not like any country is absolutely, totally market oriented or totally dependent upon the state. And China does a lot in the private sector. But we have to keep in mind, when you look at a Chinese law, and I think we've had about 30 or 40 years of blindness on this. You look at a Chinese law, usually the patent law, the antitrust law, the opening sentence is in order to further the development of socialist market economy. It doesn't say to develop a market economy. It's a socialist market economy. And that's true of almost every piece of legislation. And I think most people had dismissed this. They said, oh, China's becoming more market oriented. We know that momentum has slowed down or gotten redirected. Now, you can say, okay, I understand that on innovation, government needs to fund projects when the market fails. What does that mean in intellectual property? After all, the state is very actively involved in many market economies, even in IP. Austria will subsidize patent filings overseas. And on the far side of the equation, North Korea has a patent law. North Korea, not only that, protects patent its constitution. The North Korean constitution has a patent provision. So what does that mean to state involvement? For me, state involvement means a couple of things. I want to make it clear that these are, to me, objective criteria, not kind of, gee, China's a threat. Let's look for things that demonstrate it's a threat.
And are you also maybe for example, talking about sorry, just maybe enhance what you're talking about now, but the fact that, in China, Google and YouTube and all those things are banned, but China has their own version, and those really successful companies like Weibo and Alipay and Youku. But it's almost like those are more because they're state funded and backed by the state. They don't run into that situation of having to worry about competing with those companies, and because
so
they're the main.
they may be national champions that are privately funded, but they certainly have an advantage over foreign entrants into the market.
Right.
And this came up actually in a recent discussion. I said, what about Alibaba? I said, well, yeah, let's compare Alibaba with Apple Pay. Let's talk about or with Amazon. There's significant differences in terms of market access and strategies. But there are other elements. So some examples. China has a very big, this may surprise many Americans, very big public element of intellectual property. So you have extensive administrative enforcement. Compensated, just the infringer gets told to stop. So that's treating it like a public remedy. Or you have robust antitrust enforcement or low compensation in the courts for infringement. All of these things mean that China, or you have actually 5-year plans on intellectual property. All of these things show that China treats intellectual property as a national asset, perhaps as much as it treats it as a private asset. We don't have a 5-year plan on intellectual property. I sometimes think it would be helpful, frankly, to our courts and judges and policymakers if we had a plan about how we want to protect software patents or fintech or any of the other emerging areas. And we had a consensus about what it means, but we don't. Kind of let the market operate, sometimes to our disadvantage. And that's kind of unique. I once had a discussion with the Secretary of Commerce, actually. I had a 5-minute opportunity to kind of get her to understand what China's IP environment was like. And I said to her, imagine, Madam Secretary, that you called up the mayor of New York City. And he said, Mr. Mayor, I'm very unhappy with New York. There's only 3 patents per 10,000 people being filed in New York. And you have to meet the national standard of 3.3. And she looked at me and said, why the hell would I do that? I said, unless you understand that, you're not going to understand how the IP environment in China works. Because that was the metric. Actually, it's now about 14 per 10,000 people, perhaps higher. Right. And people get promoted on that basis. They get rewarded on that basis. They get demoted on that basis. And courts are aware of it. Everybody's aware of it. It's part of China's plans. I mean, if you step back 20 years ago, 30 years ago, the problem that the world saw in communist economies was that they wouldn't protect property rights. And if they weren't going to protect property rights, they certainly weren't going to protect intellectual property. And we built the WTO around that. We built a lot of disciplines around that. No one expected, and I give China credit for this, that a country would embrace intellectual property as a tool for its development. A communist economy would embrace it. And we're still suffering from that shock. I think we're still digesting that shock, frankly, and it's taking time. So public enforcement, yeah, please.
Maybe going to this point too, you mentioned such an interesting point about how, maybe the remedies and damages are a lot less and smaller amounts. And so it's almost like more of a slap on the wrist. And I was just teaching my patent law class, sort of the whole menu of everything from like willful damages and to injunctions. But I feel like, as we talked about before too, like in areas like Shenzhen, where they're constantly innovating and they sort of just ignore IP laws in general, and it's more of an emphasis on the innovation that the maker culture can build. Is that, are you saying sort of like not as a full bore approach for punishing IP infringement? Is that one of the reasons why China has succeeded so much in terms of being able to spread their technology and innovate?
Well, I agree with you. It's very much a maker culture. And I also think that traditionally IP protection has been very weak. And I think that China, in my view, has crafted IP regime towards its own national interests. Most countries do that. But I think in China, they've been, more creative in pursuing that. I think a good example of that and this may look like an apples and oranges comparison, I think it is the Qualcomm antitrust investigation in China. So Qualcomm was fined $175 million for abusive dominance in the way it licensed its, I guess, 4G technology and sold semiconductor chips. At that time, average patent damages in China for your typical patent infringement case were about 15,000 US dollars. If you did the math, it would take about 20,000 lawsuits where you had average patent damages to reach that $875 million. There was no relationship or correlation between the weakness of the IP system and the sense that Qualcomm was abusing its dominance. And I think there should have been, because unless you can enforce your rights, you don't have a dominant position.
Right.
But that didn't contradiction to Chinese officials. And so you do have a culture, as you call it, a maker culture, which is really focused on the licensee, the implementer, and other ways of achieving or competitive advantage, like first to market, rather than IP dependency. And I
like Darwinism, almost like just survival.
Almost like that. I mean, Shenzhen, to its credit, does have an active court system in IP.
Right, I remember that.
Boys and ZTEs do use it, and they have some good judges. But I think that is certainly the dominant aspect. Let me say another thing about dominance too. That I think this is one of the areas where, again, we have to be really careful and incomplete information. But I think the general observation is that the Chinese IP system is dominated by Chinese actors to a far greater extent than the U.S. system dominated by U.S. actors or the European system by European actors. So, what I mean by that, if you look at, for example, patent applications, 85% of invention patent applications, what we call utility applications, are filed by Chinese. In utility models, what are called petty patents, which the US does not have, it's about 99.5% filed by Chinese.
Right.
Trademarks, probably about 80-90%. Litigation, 99% or so, Chinese versus Chinese. So you have a system that is overwhelmingly self-focused. And this is kind of like, it's hard to digest this because if it's so self-focused, yet at the same time, according to available data, foreigners do pretty well in the Chinese courts. So how can you take these two buckets of information that foreigners are not utilizing the system?
It's almost also is true in the U.S. Foreigners don't do so well.
Yeah, absolutely. And I think maybe this is a problem with the data, but I think this is also because foreigners only litigate in China when it's really important. So you have a bit of self-selection. You have, for example, foreigners routinely bring cases, a very high percentage of cases, against the Chinese Patent Office. You have a patent for 20 years. I mean, you can almost imagine the board of directors of an Intel or an IBM, and they're thinking about how much you spend on legal fees. And they're saying, China can change in the next 20 years. I have to protect my patent rights.
Right.
But litigate in China, I don't know if I have enough confidence that it'll be a decent result. So the result is kind of we still have this kind of long range view, even at this stage, I think, on the IP system in China. And we don't really use it for infringement purposes, although we complain a lot about it. The other thing where we don't, and this goes more into my last observation about what needs to be done, but just to give you a taste of that, the other thing we really have not insisted on, which is really critical, is on greater transparency. So, we asked China to bring more criminal cases. Phase 1 agreement, have punitive damages, reversals of burden of proof. If you want to know how courts are handling these new requirements, you need transparency. You need to have all the cases published. If you want to know if foreigners are being biased, if there's discrimination against foreigners, you need all the cases to be published. In fact, not just the final cases, you need the interim decisions, the preliminary injunctions, whatever else happens before the final decision. And we've never really requested that. And actually, most recently, the WTO, we refrained from requesting it when the EU made a request of certain cases. So it's really, I would say our engagement here is not particularly optimal, considering the disadvantages we face and problems in accessing the information.
So those documents basically are by default, almost like under a protective order, like in the States, and you would have to file specific. They're only viewable by the parties involved with the.
Well, it's kind of skipping to another point, but it's an important one. Let me say a few things about that. First of all, China is now a rich source of information on intellectual property.
Right.
I don't think, even with the existing information, I don't think it's been fully mined. So you have the biggest patent office in the world, I don't know, 3 or 4 times the number of filings of the United States on utility patents, biggest trademark office in the world, maybe 10 times the number of applications in the United States, and about 400,000 civil cases a year, maybe 40 times the United States. That's a lot of activity. And that's not even counting the administrative system. Mining that can be extremely useful. I know one area where we've recently done programs that I've had students doing research on, plant varieties. China is a leading country in use of molecular markers, DNA technology, to determine if you're infringing a protected plant variety. And they've had great cases defining the scope of infringement. No other country, as far as I know, is that far advanced. So there's really information to be gathered from this that would benefit our own system, not to be ignored. Typically, this is Chinese versus Chinese, but you can imagine with robust fintech patents, with AI-related technologies, we go down the list, there's going to be a lot of information there that would be useful for judges and for others trying to come up with appropriate ways of resolving contentious cases.
I think like a company like Docker Navigator, I think would make a killing if they try to make a software tool just specifically geared towards collecting and mining that data and organizing it. A really interesting issue that I think that you brought up, and going back to the foreigner versus Chinese company setup in litigation, I was curious as to when you have maybe a foreigner going up against a Chinese company in China, is there an equivalent to the U.S. International Trade Commission in China that one of the remedies available to you is like an exclusion order that prevents the goods?
Great question. Great question. So a few things about that. First of all, the short answer is that yes, theoretically, there's a foreign trade law of China, which theoretically authorizes the Ministry of Commerce to have these administrative remedies to exclude products from entering the Chinese market. It's never been used.
Oh, really?
Why hasn't it been used? The reason is litigation in China is very fast. And the customs authorities will also detain infringing goods that are imported that infringe patents or any other IP rights. So unlike US customs, which only detains trademark and copyright infringing goods, Chinese customs will seize goods on import that involve patents. But the other thing that I want to focus on here, because this also deals with your, I think, astute maker culture observation, is that Chinese IP is on a very short time frame. In litigation, first instance cases for a patent dispute typically average around 7 months. Appeals are 3 months.
Wow.
So you may wonder, I want to get a preliminary injunction. In the US, it will take 10 months or 11 months before I get a preliminary injunction.
Even in the Eastern District of Texas, that's the fastest court, I think.
And in China, you will have exhausted your appeals before you've even concluded the discovery stage in the Eastern District of Texas or the Northern District.
Right. I've seen that used often in the playbook of companies who try to use the Chinese cases.
Absolutely. Qualcomm versus Apple, global litigation. The first court to issue a preliminary injunction against Apple was the Fuzhou Intermediate Court. Fastest
so maybe
in the world.
Right, exactly. And I guess maybe going back to the 3 points that you made, did you maybe want to round those out, or have you sort of finished talking about I guess the third and final point.
Oh, okay. Well, let me just go through these. But I think your questions are very useful. Yeah. So let me just talk a little bit about the threat and remedies, kind of giving you a sense, I think, of the Chinese IP system. I mean, it's important to keep in mind, I think, just to wrap that topic up, that the press doesn't, or even the government doesn't necessarily get it right. I mean, you saw a lot of talk in the Phase 1 agreement from President Trump and others about China needs to bring more criminal cases, for example. Well, China that year had about 60 times more criminal cases than the United States in that collection operation. Right. 60 times. U.S. doesn't bring that many criminal cases. IP is primarily protected as a civil remedy, and China has about 40 times the number of cases. It's really the quality of the case that matters. You know, is it a serious infringement, whether civil or criminal? Is there an appropriate remedy? So just say bring more criminal cases. And the other risk there is you could have criminal cases brought against foreigners. Right now, the latest data that I saw was almost half of the criminal trade secret cases are Chinese against foreigners. So they simply think that because you're asking for more deterrence, it's going to necessarily work in your favor.
That's exact mirror reflection between.
This is a very different. I mean, when I was in the government in the first time around, and USTR would come out with these reports, China used to have remedies. You will see in those reports I came 15 years ago, the language consistent rule of law. That was always my interjection, because the last thing I want is a society without strong democratic underpinnings simply go around and seize people and lock up goods without any due process. That's going to work against you in the long run. And I think that we've mostly focused on results. Let me talk for a little bit about threat. There's a lot of concern about dominance of a range of technologies. And I think it's extremely important that folks understand that frequently these reports, aggregate technologies. They create an appearance they induce anxiety. In some cases, it's quite legitimate, but in many instances, it isn't really parsed apart. For example, China provides massive subsidies anyway until they were phased out, or beginning to be phased out earlier this year. The cost of applying patent was basically fully subsidized by the Chinese government. In fact, it was profitable to make a profit by filing for a patent. So what happened, and there's academic studies on this, to give one example, in one town in Zhejiang province, when the subsidies came out, the number of patents tripled. But the number of claims on each patent went down by 2/3. So basically, you had previously the average number of claims was 3. Now the average number of claims is 1. You really had no real difference in inventive activity. It's just people were kind of gaming the system. Plus, a lot of the patents are not being maintained, so that you didn't have to pay the maintenance fee. It was never commercialized. Nothing ever happened. Another very good example of this, when you look at these patent numbers, is, and you have to be careful and critical, is you see a lot of academic patenting in China. Now, basically, if you have a valuable patent in China, you're probably going to try to patent that in the name of a private enterprise, where you can reap all the benefits from commercializing it. A lot of the patenting in China in academic institutions exists for purposes of obtaining tenure or getting a dissertation approved. A lot of
the professors, engineering
professors are doing it for non-commercial reasons. And there's a wealth of these incentives, including subsidies, including, for example, in many prisons in China, you can get your sentence reduced by filing patents. In some cities in China, you can get a valuable residency card, it's called a hukou, by having a certain number of patents to your name. So these are non-commercial reasons. And
are they also exempted from litigation? Because in my patent law class, we taught Meade versus Duke, and it was all about, if you are using it for a non-commercial purpose, then it can be an exception to infringement. And is that one of the you know,
Well,
safe harbors.
You do have a robust research exemption.
Oh, interesting.
But beyond that, I don't know of any general non-commercial exemptions. Another example, by the way, which is very important, all this talk around 5G, is not so much a subsidy. Huawei is not so much a subsidy on patenting, although it does exist, but there's a subsidy on participating in standards activities. So we have a huge ramp up the past several years in participation in standards. You also have a subsidy for filing patents overseas that usually limits the number of countries you can file if it's a PCT application, or if it's using Paris Convention, to 2. So what you have is a situation where when China uses Patent Cooperation Treaty under WIPO, they generally only file in 1 or 2 countries. Whereas if you compare it to, a Scandinavian country or Israel or even the United States, we're filing in multiple countries. So most of the time people use like PCT applications as a benchmark for being innovative.
Right.
In China, it's a distorted benchmark because it's largely responsive to subsidy. Now, is there going to be gold in the lead? Absolutely. I'm not saying that China's not innovating at all. I'm saying these gross numbers don't really tell you that much. It's really big to find the gold in the lead. And so that's why I'm less concerned about high numbers of scientific publications, large numbers of patents, all that. That doesn't concern me that much. I want, where is China innovating? Where are highly cited articles, the patents that are driving particular standards or patent families and the like? That's meaningful. So let me just go to the last point here. Yeah, please.
Well, I guess, I was curious too about maybe the concept of standard essential patents in China, especially with respect to 5G and Huawei. Is that something as observed as it is here in the States, where it's almost this mix of antitrust law, almost like a way to prevent competitors in that respect? Or is it something where it's not treated as or emphasized as much as it is in the U.S.?
Well, there certainly has been a very robust academic and government engagement on standardization in China. And for the longest time, China was looking at patents that were adopted into global standards, 5G and the like, as per se dominant if they were reflected in a standard. I think China has begun to recognize that even patents declared as standard really are not necessarily essential to the implementation of the standard. But I think China bought into, Mark Lemley and others' arguments around patent holdup, that you could abuse the patent system when patents are incorporated into standards, and took a fairly aggressive view. I think the system has become more mature and sophisticated, but it's a maker-oriented culture, to borrow your term, Tim. And I think that means that generally it weighs in on behalf of the implementer. There are problems with that because companies like Huawei are big patentees, big participants in standard setting. And so I think the Chinese government is changing, but maybe not changing fast enough for some people in the West, and maybe not changing in a way that's adequately balanced between foreign and domestic. It's not so much implementer versus patentee, maybe it's foreign versus domestic. For a long time, I never wrote this article, but 5 or 10 years ago, I was thinking of writing an article on the China price for technology. It used to be if you were buying sneakers or clothing or some consumer good, you go to China, you go to the Canton Trade Fair, or you're negotiating elsewhere, and you say, what's the China price? As if that would be the lowest price possible. Right. And now you have China really beginning to set prices on technology. So you have a litigation, brought by Conversant, a technology license, and the royalty rate that the German court established for use of the technology in China was 18.3 times higher than the Chinese court. So the China's saying we pay less because it's a maker technology, a maker-oriented society, or maybe because it just wants to pay less. And this is the way it fosters its own competitiveness. And this is a real challenge, I think, to foreign companies, particularly in the US. We're the largest lab technology in the world. We do about $140 billion worth of technology licensing every year. And we're really the most active, and we have a trade surplus in this area. And often the principal, if not the only market, for example, for 5G technologies for cell phones and handsets. So the Chinese price for technology poses a lot of risk to American competitiveness, in my view. So the question is, what can we do about it? I just to kind of end on that, because I think my own view, looking back over the past 10 or 20 years and 13 years in government service, is that we did not have a sufficiently agile or deep core of government officials that were paying attention to China's technological emergence. And I can remember many incidents. And it's simply saying that China is a threat. It's also about where is it a threat? How is it a threat? The emerging technologies. How should we cooperate with China? I think DOD and the defense establishment have done a very good job, as far as I can tell, in understanding the impact of China's technological emergence. But in the civil technologies, and of course, the gap between civil technologies and security-related technology is pretty narrow these days. Right. It hasn't been that effective. Listen to Catherine Tai, the U.S. Trade Representative, in some of her recent speeches. She hardly mentions intellectual property. And of course, today we just had our confirmation hearing for Ms. Vidal, who's as the new PTO director. That's a year into the Biden administration. A lot of the policies are already set on IP. And we really need a core of people who can skillfully navigate these issues and mine the data. I mean, China is a pretty complex and sophisticated environment for intellectual property. You may want to, discount the legal and say, the government is interfering, the party dominates, but still it is a complicated environment. Every major IP law was revised the past year. Litigation, the size of the agencies, all are multiples of the US. And it takes time to really digest these things and respond accordingly. We still don't have a lot of people in the government who have either a STEM background or a policy background and a Chinese background to really understand these issues. And I think this has to be a long-range goal. I think, in my view, the best way of managing it is to improve U.S. competitiveness and come to our, challenges with China, a position of strength. And one of the other important components of that is really looking a little bit more carefully about how we've managed this issue over the past 20 years. One of the things that has recently disappointed me, and I briefly mentioned it earlier, is that in July of this year, the European Union submitted a request to the WTO to demand that China publish 4 cases involving standards essential patents. This is so-called Article 63 request. Now, 2 of those cases directly implicated American interests. One of them said they wanted to know the case that Samsung filed against Ericsson in Wuhan, China. They wanted the case decisions. Well, Ericsson filed a case against Samsung in the Western District of Texas, I think it was. And we know about the Wuhan case because it was referenced in the Texas filings.
Right.
So okay, and not only that, Samsung and Ericsson, these biggest market is the United States, not China.
Right.
So the U.S. had real interests here. The other case was Interdigital and Xiaomi. And Interdigital is a Delaware-based company. So the EU was saying, we want to know what happened to Interdigital in this case in Wuhan, because a court in New Delhi, India, of all places, said that they were not going to respect the Chinese court's decision that they had to stop their litigation. So here you have the EU demanding information about 4 cases, 2 of which directly implicate American interests. And the request is simply, give us copies of these cases. Not saying, not weighing in, you decided it wrongly, fairly, it could have been decided this way or that way. Nothing just about access. That. Just give us the copies of the cases. Pretty darn basic, in my opinion. And the United States did nothing. We did not even send a letter, we support the EU request. And this is despite the rhetoric about we're going to support multilateralism, we're going to work with the EU or Japan or our allies, we're going to rebuild the WTO, we're going to strengthen American innovation. All that rhetoric, at least in terms of this case, proved to be hogwash. So, you know, to me, I think you cannot have an effective IP regime unless you also have a commitment to rule of law. And we cannot detach the two. And if we're going to talk about whether China is fair or not, the first step is to insist on transparency. And we didn't. We missed that one. And frankly, shame on us.
And it's so interesting too, I guess, you know, like there's almost this paranoia about 5G, 6G, and Huawei, and it's almost like it's you know, the American parties who are always like either suing Huawei or being sued by Huawei always try to bring up the notion of, oh, this is like this, you know, giant foreign conglomerate that has this dominance over and even I was thinking, you know, for smartphone technologies, there's even like specific types of, you know, like dual SIM card phones or things like that are only available in China, and in many ways
China pioneered that, actually.
Yeah. So there's many things that actually, you know, China should be afraid of maybe the United States copying, and especially as they develop in terms of
that day may happen soon. I mean, China is becoming more active. As Huawei, I think, is the largest litigator overseas of IP rights.
They would always be in the China.
And also, frankly, as Huawei is concerned, you know, if you're going to say to Huawei, you can't participate in the U.S. market, you can't build base stations, or you can't sell your cell phones, they pose a risk. They have a rich bundle of patents. It's not surprising that they're going to try to monetize, commercialize, litigate those patents, and be dependent on that for revenue when they can't sell the finished product. And Huawei is what I call an overseas practicing entity. They can't practice in the US, but they'll practice in other countries. So when it comes to the United States, they just, you know, they're like an MPE. I mean, they really need to get that revenue. Yeah, it's one of the oddities. You know, we can shut companies out of the market through export controls and investment restrictions. But when it comes to IP, we have obligations about national treatment and TRIPS obligations, et cetera. It's a little harder to do. And it's interesting that, you know, during the Trump period, we had a big incident involving Micron. I don't know if you remember this. Micron claimed that a Taiwanese company stole its technology and was making it available to a startup state-funded entity in Fujian province. And they were sued in Fujian. They sued in the United States. They sued in Taiwan. But what ultimately put an end to this theft was that the Treasury Department or Commerce, I forgot which, deemed it an unreliable entity, and that it prohibited U.S. companies from selling technology to this Micron would-be competitor. So we used export controls to resolve an IP case. Now, I doubt
creative solution.
I had a bit of a shudder because I doubt the folks at the Commerce Department considered the fairness of the claims of Micron or of the Chinese party. They were relying on the assertions of the U.S. company. but they felt like it was an issue that concerned national security. And the only way to handle it was to ban them entirely from receiving US technology, which was, I believe, was a kiss of death. So you really have these IP and security issues bleeding into non-traditional areas like export controls. And sometimes that's where the remedy is, not in an infringement dispute.
Right. We very much like that ITC's interdisposal and non-monetary remedies like injunctions.
Right. Exactly. Yeah. The ITC is another very China undercuts ITC cases. They have in the past. And someone, maybe you'd be the person, Tim, could write an article about how Chinese cases sometimes seem to have been timed, based on calendars at the ITC. So complete, get your first judgment before discovery is over. This kind of thing. This happened in the InterDigital Huawei case, which was an ITC case, and there was a corresponding antitrust case in China. And there was another case involving a company called Goartec and Knowles that made microphones for cell phones. And it seemed like the docket in China was kind of responsive to the US docket at the ITC. Try to undercut it because they move faster in China. The other thing is not only they move faster, but they have the flexibility. China's civil procedure law, forgotten what article it was, basically says first instance cases, your first case, 6 months, appeal 3 months, 9 months, the total dispute. But if it involves a foreigner, those time limits can be changed.
Extended?
Yes, they do. So this could be a real tool. If you're a defendant, a Chinese defendant, you go to the court and say, you have latitude, Your Honor. I have to gather more evidence. It's a foreign company. They probably have to get authorization. I don't know if they're really authorized to bring this case. Who's the real owner? And the next thing you know, I have a case that lasts years if you're a Chinese defendant. If you're a plaintiff, you're going to try to have those times shrunk really quickly so you can move the case really fast along and maybe even undercut a parallel case in another jurisdiction. It's a big advantage to a Chinese litigant to have this flexible time frame.
Absolutely, yeah. It's similar to how, even in the States too, about timing IPRs with and trying to stay a case, pending resolution of IPR, and maybe even like people say or Judge Albright says he can beat the PTAB, but I'm sure no one can beat one of China's lightning fast courts or their determinations.
It's not only fast in the courts. I mean, the agencies are fast too. I mean, particularly on these kind of smaller rights like utility models or design patents, you can get them in 2 months. I teach my Chinese IP class. One of my friends had told me, why don't you have the students apply for your utility model the first day of class? And in 2 months, they'll get a patent. Typically in the past, they weren't even examined. Everybody could walk away with a patent for a couple of $100s. The other thing, on the positive side of the equation, at least for me, China has an IP system that, despite all our talk about China Inc. and dominance of the state, there's a robust small enterprise individual element to the IP system. So you have about 30% of the patents filed by individuals or small entities, compared to about 5 or 6% in the United States. You have a lot of litigation, 20 to 30% perhaps.
Do they give discounts on filing fees and for
micro entity type? And not only that, unlike the US, when you file in China, I think it's good for 2 years. You don't have to go ahead and say I'm a micro entity again and again and again.
Oh wow!
Do the application and that's it. So it reduces the paperwork as well. The result is a system that maybe it produces junk, but I'm sure there's some gold in the lead. But also it's really geared towards engaging small individuals and enterprises. In the U.S., we kind of suffer under this delusion that we're the land of Thomas Edison and Birdseye and Land and Bill Gates and whatever else, when our IP system is largely corporatized. China, and we think that China is largely state-driven. when in fact, it's really one of the distinguishing characteristics that there's a relative easy, less expensive access to the agencies and the courts. In fact, it used to be, they just changed this, that you didn't
Is it
even
like a
have
pay to
to
play
file,
system?
a little
Only the rich
bit. No,
can
I think
afford.
it's mostly subsidized. You used to be able to go to court in China on a civil dispute, and you didn't have to file a written complaint. Someone would write it down for you if you were not literate or didn't know the nature of your complaint.
Oh, interesting.
And the first week of the dispute or so,
Like a pro se.
it's like a pro se, but they would facilitate, and they just started setting up small claims courts. So there's actually, I think there's something to be learned about China's small enterprise engagement, including things like open source types of innovation that might be useful for the United States.
Absolutely. It's really
Oh, thank you so much, Mark, for your comments, and thank you, Professor Hsieh, for your thoughtful comments and feedback. And let me raise two questions in light of the discussion, and circle back to the theme of this discussion. That is the IPR and U.S. tech rivalry. My questions are really on two sides of the question. The implications of the IPR development for the tech rivalry, and the implications of the tech rivalry for the IPR regimes. And so far as the first one is concerned, I wonder, in light of the recent development of the IPR system in China, whether, Mark, you see more convergence or divergence between the IPR system in the US and China, and what are the implications of China's, the recent development of IPR regime for the ability of China to continue to innovate? You portrayed a very interesting picture, right? China's system seems to be now sort of more friendly towards small and medium players, whereas the U.S. system is more in favor of the established corporate titans, right? So can you elaborate a little bit more on the implications of the recent developments, particularly in China? Because as I think, if I understood you correctly, you are saying, we actually don't understand enough what China has done, particularly over the past couple of years. China, so much has happened, right?
Right. No, I can tell you, as someone who teaches IP issue at Berkeley Law, Chinese IP at Berkeley Law, every year I teach it once a year. I'm teaching it this spring. I dread it. I love it, but I dread it. I dread it because so much changes over the course of a year. And I have to go back and revise and rewrite my materials and read everything again. So it keeps me current. But the past year, every major law was changed. And then a lot of the judicial practice, et cetera. So this is a very fast moving, very responsive environment. I also would put that down, Tim, about one of the characteristics of China's IP environment. It's highly responsive. Now, one of the examples I'd like to give about complementarity in tech rivalry or competition is an area of software patents, fintech, and genetically inventions. The U.S. has really scaled back on patent eligibility for these types of inventions. Made it harder. We've imposed different kinds of requirements through a series of Supreme Court cases. I'm sure is very familiar with all of them. At the same time that the U.S. was doing this, China was ramping up, making it easier in these three exact fields. Now, in fact, the timing was so short that some people thought that China was trying to once again eat our lunch. But I think this is really China being responsive to where it saw innovation going. I have a lot of software programmers. They were doing a lot in fintech, as Timothy opened up. And in fact, there are a few this. there were many instances where US companies could not obtain a patent in the US on those technologies, but could in China.
Right.
This is an area I view it as a bit of self-weakening. Now, some people may say, oh, we should weaken our patent system for various reasons. And you may think that the US has a competitive advantage. And in fact, we don't have much data around how much that has contributed to investment and entrepreneurship, new enterprise formation, willingness to pursue particular technologies. But in principle, it looks a bit odd. The US actually weakened itself in an area where China was strengthening itself, and which relate to area AI and the like. So
I think that's such a fascinating, topic, especially for how China is like light years ahead in terms of fintech, and it's a totally cashless society, and everything is based on just like scanning a barcode or QR code. And I was curious as to, do you think that's actually a better thing for this state-of-the-art technology in terms of fintech, for convenience, and the fact that maybe you're awarding these patents that would be allowable in China but unallowable in US due to 101? And I was another thing, sort of a corollary to that question, was that when are these laws like sort of statutes that are passed based on a legislative system that's similar to the Congress legislative branch we have here? And is it something where, like you were mentioning, the rapid fire pace in which the laws change? Is that something that's constantly like almost like a dynamic congressional process, or is there some pushback to, or is it very difficult to get a law changed? And it seems like it is a lot easier than it is in
right. So first of all, China has changed its IP laws with greater frequency than the United States, so in general, and the recent spout of the recent activities,
right,
precipitated in part by the trade war and the Phase 1 trade agreement, is another example of that. Let me take the second part of your question first. When I'm talking about relaxation of patenting requirements, I'm talking about changing of China's patent examination guidelines, very similar to the United States. Statute was not changed for the most part, but the practices of examiners was. There's another interesting element to that, or at least two other interesting elements of that. One is that China will not retroactively impose more stringent requirements. So if the Chinese Supreme Court says, you need to do X for a pharmaceutical patent in terms of the kind of testing that is required after the application to show the safety and efficacy of a pharmaceutical product, that will not be imposed retroactively on prior patent grants. The US, when the US says that for software patent, you need to do X, or genetic invention, you need to do Y, that ends up resulting in re-examinations of previously granted patents or invalidity declarations. So there's a greater stability built into the Chinese patent against future developments. That's actually, I think, a significant advantage. The other point I'd like to make here, and in this, pardon me, I don't intend to sound like a communist, but I'm going to have to for a moment. A 5-year plan or a 15-year science and technology plan that says we are going to pursue AI, we're going to pursue facial recognition technology, we're going to develop our fintech to do X, Y, and Z, that is adopted at high levels of the state, necessarily impacts the behavior of the patent office, the courts, et cetera, where there are judgments to be made. Our Supreme Court does not have a 15-year plan for technology because the United States does not have a 15-year plan. So when these guys, these 9 men and women of the Supreme Court, decide a patent dispute, among the other hundreds of other cases they're deciding, they have no reference point. They're reading the New York Times and saying, patent trolls are a bad thing, patents are a bad thing, we got to stop these software patents. It's not an in-depth consideration of the kind that would go into a 5-year plan. And I think this is actually a strategic advantage of China. In many respects, I view it as a disadvantage if you're constrained about what you can do, ability to innovate. But in this case, the state has thought it over and has a sense of the direction the country wants to go. And this helps guide things going forward. I view that as an advantage. I've often said that I wish our Supreme Court had a 5-year science plan. I think it would really
Right.
help in making these complicated decisions.
Especially
Mark,
with the House
there's a
mandate.
question from our audience. Here is how the question goes. It appears that China has a highly preferential domestic and insular focus, but will this inevitably open the door for reciprocal treatment by US and EU countries and diminish some of their IP export allure? I'm thinking of the divergent SEPs and technical regimes and whether it's reasonable for a company to gamble on litigations versus good faith development in China.
So this is a,
That's from
looking.
Michael Turner, one of my Pan Law students, by the way.
What was that, Tim? I didn't hear it.
One of my Pan Law students, Michael Turner, he asked that question.
Yeah. Oh, okay. Well, it's a good question. People are raising this now in terms of the battles over standards essential patents, and particularly in light of recent Chinese judicial decisions, including some Supreme People's Court guidance that's been issued from China. For example, in a recent decision involving Oppo and Sharp, a Japanese company, the Supreme Court said that a jurisdictional basis for determining a worldwide royalty rate for a standards essential patent portfolio is where the negotiations took place. Now, this is nowhere in China's civil procedure law. And to me, this suggests that if you're negotiating with China, you run the risk of being sued in China now to a much greater extent than a few years ago. In a global pandemic, if I call up Oppo and say, let's talk about my patents, am I negotiating in China? Is a Zoom call a negotiation in China? Am I subjecting myself to China making a determination about royalty rates? It's a good reason to stay away from China and meet the Oppo guy through Singapore or London or wherever else, but avoid it entirely. And some people are saying, like the Conversant case, the Chinese court made a decision that the royalty rate was 1/18.3 of the German royalty rate. Okay, 1/18th approximately. Now, maybe Conversant or other companies will say, you know what? I'm not going to file for patents in China. It's not worth it. It's such a low royalty rate. And I'm going to subject myself to the Chinese courts. So I'm just going to acquire patents in Germany, in the UK, in the United States, et cetera, and exert pressure there. And we've seen this already in litigation tactics. InterDigital brought a case in New Delhi. Another company called Vringo brought cases in Romania, Brazil, and a bunch of other places where they could put pressure on China. So there is this gaming going on, if you will. And I think some companies, particularly those that are not manufacturing in China or that have pulled out of manufacturing in China, are thinking about how they can leverage that to their advantage. But a lot of companies, you cannot give up on the Chinese market. I mean, if you're in 5G, if you're in many other areas, even pharma and biotech, it's too big a market. And you're going to be stuck with manufacturing and other operations. So those possibilities are going to be much less. Samsung is largely pulled out of the Chinese market. So that's an example of a big Korean company that is pulled out and is probably using legal strategies outside of China. Reciprocity, getting the other part of that question, the WTO doesn't has standards other than reciprocity. In my view, I think thinking of things through reciprocal terms is sometimes more useful than thinking about whether foreigners are treated equally to Chinese companies. If you have a non-transparent environment in China, like I said before, where not all the court cases are made available, you're going to have a hard time coming to a firm conclusion about whether foreigners are treated fairly or not. But on the other hand, it's a lot easier to say, you know what? I permit Chinese law students to practice law in the United States. How come American lawyers can't practice law in China?
I don't know.
As one example, and there are many other examples. So I think reciprocity is a good negotiating position even if it's not as well founded under international trade disciplines. I think, for example, this notion that timeframes in civil procedure, what I just mentioned, can be relaxed if there's a foreigner involved, pretty darn inappropriate. And so there are many other places where we should be insisting on some kind of equal treatment. Now, whether it's a problem for China to mandate, the China price for technology, and what would be the arguments for or against that is actually an extremely important question as well. To me, it's more about industrial policy than reciprocity. I think China wants to lower prices for imports. Technology is an import. Drive it down as cheaply as possible. But when Chinese come to litigate in other countries, we should also think about the value to a Huawei of suing in the United States, perhaps on reciprocal terms. Maybe they should get a 1/18th discount.
There's another question about 5-year plans. Can you talk about how recent plans and pronouncements from the CCP signaling that IP authorities and courts should use IP as a tool for national development, and can potentially undermine the fair and non-discriminatory treatment of IP owned by foreign.
This has been a long-standing concern. I think as IP has become more deeply and consistently recognized as a tool for national development in China, it's become more prominent. There's a lot of focus these days on what China calls bottleneck technology. This is partially responsive to export bans from the United States on critical technologies, and where China wants to drive down prices on either the technology or products incorporating the technology. And they leverage some of their set litigation tools around that if it's incorporated into a standard. But this has a long history to it. And again, I don't think we're looking at as much at a revolution in China's approaches as to issues that we chose to ignore in the past. Philips was a leader in optical media patents and technology. And for the longest time, Chinese companies, this is 20 years ago, were complaining about Philips royalty rates. There was not a lot of Chinese improvements or inventions around Philips technology, but they tried to use every tool in the book, including bringing antitrust cases in the United States, and including having their minister, who was then in charge of competition, threatening an antitrust case when there was no antitrust law. That was the Minister of the State Administration for Industry and Commerce. So they were trying to drive down the prices of foreign technology when they were a maker culture for optical media. I think they were producing 90% of the CD and DVD readers in the world at that time. And we've seen this repeated over and over again. When InterDigital was sued by, it was around 2007, the judge in the Chinese court, I think it was the Guangdong High Court, held a press conference afterwards. And he said, using antitrust to drive down prices of foreign technology is a good tool, and other Chinese companies should learn from Huawei. Now, when does a judge make a speech like that? I mean, that's a huge sacrifice of independence. Another case I remember quite well was actually a 337 case, Timothy. You were talking about 337 cases. This case involved a company in Schenectady, New York, that made rubber tackifiers, hardening chemicals for rubber. And it was a trade secret case in the United States and a trade secret case in China, parallel case. Actually, there was an attempt to bring a police investigation in China. It went well, but at the last minute, the police backed out, and there was a civil case. After the intermediate court, the first instance court, rendered its decision, of course, contrary to the US ITC. Another one of these cases that almost seemed to be planned to undermine the US ITC case. The Supreme People's Court said, this is a great case. This shows how you can use Chinese civil procedures to address an ITC case. And they also said that, in fact, and they misread the ITC case. The ITC case decision looks like it's going to be very similar to the US. They misread the US case. I actually wrote a letter to the Supreme People's Court. Said, this case is going on appeal. How can you go ahead and appear to be unbiased when you're saying the lower court decision is so well founded? It's going on appeal to your court. This is unacceptable behavior. I didn't say that part. But this is utterly unacceptable. So we've seen, you have to look, but we have seen time and time again the fingerprints of industrial policy and politics on Chinese court decisions. Now, that being said, I don't think, and this is just my impressions, I have no firm research to back this up, but I don't think that most cases suffer from heavy political influence. So if it's kind of a run-of-the-mill patent case, trademark case, copyright case, it will work its way through the courts. There are very good judges. They want to do the right thing for the most part. They really don't like political interference. They're more expert than US judges because they really have trained on intellectual property and have a high docket. And you'll probably be treated fairly. But the problem is when roughly 30% of the court cases are not published, and you have a small cohort of foreign cases, you're constantly left wondering, what's in that 30% that's not published? What am I not hearing, and what is its significance? I can tell you, for example, that the court case where there were the largest patent damages in Chinese history was a case filed by a company called Zhongtai Chint in Wenzhou, China, against Schneider Electric, a German-French company, the big US presence. That was the first instance decision was good 10 years ago, 330 million RMB. Never published. The case involving Micron in Fujian province, I just spoke about, never published. Another case involving a semiconductor equipment manufacturer called Vico, preliminary injunction in Fujian province, never published. There was a parallel case in the Eastern District of New York in Brooklyn, took the judge 9 months to issue a preliminary injunction. That was published. That was 80 pages. Right. My understanding is the case in Fujian was a lot shorter than that, and probably responsive to political pressure. So it's really this is like, if you look at Chinese legal system as kind of a picture of Red Square in Moscow, and you're looking at who is missing from the picture from last year. It's what's missing that becomes more important. And that really undermines the confidence in what you're hearing and what you assume about how the legal system operates, particularly for foreigners, because we're a small part of that environment, an important part and a politically charged part. But with the absence of complete transparency, we really can't say what's going on with complete assurance.
Do you think China will never really have anything close to a FOIA statute or anything that just encourages transparency? And I mean, even just the fundamental nature of the U.S. courts, the state or federal, is really just the fact that you're communicating to the public through
right,
and then you can find.
Well, I can tell you, I think the big thing that China needs, because they do have China has gone from almost complete darkness to, let's say, a high degree of luminosity, but not complete transparency in the past 5 or 6 years. So it is possible to strategize, look at how the courts are functioning based on available data, but you're always going to have this second thought. What China lacks is a pacer system, something that will tell you about everything that's on the docket. Right. So in this important area of SEPs, Standards Essential Patents, I can tell you that one Chinese law firm did some research. They found 160 SEP cases over the past 10 years. there are maybe 5 published decisions.
Right.
Most of the cases settle, so there's no final decision, but it'd be really interesting to know about what happened before the settlement. And we don't know. We don't know. So it really, we're far from a level where we can talk about things with great assurance. And I think it undermines a lot of the really good things that China has done. I mean, it's the bad cases that people remember. They don't remember the routine good cases. And there are so many bad cases that get reported in the press that appear in a New Delhi court case or an Eastern District of Texas court case, but are never in the Chinese docket. People are left thinking, what really happened there? We don't know.
I guess they even have the citation, but it just doesn't do you any good because you can't look it up or
right
track it down. That's fascinating.
Right. And Mark, maybe Professor Hsieh as well, in light of the growing tech rivalry between China and the United States, do you guys think that the IP or the divergence in the IP regimes might further fragment the tech world that we'll be seeing down the road?
Yeah, I know you partially asked this question before. I didn't respond. I apologize. I want to make a few quick observations about this, and I'll turn to Professor Hsieh afterwards. One is that even during the middle of the trade war, the U.S. Patent Office continued to be engaged with the Chinese Patent Office. There's a long history of exchanges. This is a highly standardized, harmonized area, patent law. We've had the TRIPS agreement. We have a range of international treaties. Most, particularly developed countries, things pretty similarly. Certainly, the similarities outweigh the differences, at least in terms of the law and the examination guidelines. And I think relationships are actually pretty good at that technical level. It's not like the tech rivalry. It doesn't implicate in this way, kind of the market access issues, who's going to come on first, etc. But I have to say as well that STEM-related exchanges, for those of us who have followed this, have been really critical to the bilateral relationship. I mean, with many countries, it began with science exchanges. I mean, people have something to learn from each other. It develops a collaborative approach. They come up with new products, new ideas. It's just a very productive way of doing things. And generally, and you would know this better than some of the best science comes from exchanging ideas with people from other countries. Some of the more widely cited in publications. Science have generally been, I think, pretty good. IP exchange is also pretty good. IPO has a bar, the Chinese Patent Office is a bar liaison council. I think they're having this meeting next week, engaging with US patent lawyers and the like about examination practices and other technical areas. The problem is, when it comes to politics, things start looking very differently. And there certainly are many legitimate concerns about fairness of how China is and bias and the like. And I've talked about many of them. I think that we may continue to see more fragmentation, notwithstanding the fact that there's been a lot of collaboration. I mean, how far that goes, I don't know. I mean, the WTO, I think, has been weakened, not just by Donald Trump, but the appellate body and other organizations. We're seeing in these global disputes over standards essential patents, how local courts and national courts are driving international policy in the lack of a framework where people can talk about what's fair, what's a good process, what's a reasonable royalty. So that I think there's a great deal of fragmentation, and it may yet impact further science and IP collaboration.
Yeah, absolutely. I feel those are all excellent points. And I mean, just as an example too, like blockchain, I feel China has always been leading that effort, and that recent, I guess that law legislation is sort of banning any cryptocurrency transaction, and that has led to a lot of these Chinese Bitcoin mining companies to come to, of all places, Texas, and trying to get some of that stuff going on, maybe in Oklahoma. But it's an interesting development in terms of something that would be, you would think, like China being the leader of all things fintech related would really try to develop what we have here in terms of like Coinbase and all these cryptocurrency trading platforms and NFTs. And just because they decided that maybe cryptocurrencies can be used for like illegal things or things that are sort of under the table and shady deals, that they as a result, a lot of those innovators in that space are coming to the United States. And I think it's especially with blockchain, I feel like that could be something too that the United States could learn from China with regards to how you would properly design subject matter eligibility laws to properly foster the growth of the fintech industry, and especially things with blockchain and NFTs and cryptocurrencies. I really feel like that's something where maybe both countries could work together on in terms of developing a pushing that space forward, especially in terms of like IP innovation.
Professor Cohen, another thing I think that's important is I think a lot of U.S. institutions, government and state are still very focused on the U.S. market. A lot of them, I know the federal government rarely files patents overseas. Berkeley, I know I've spoken to the tech transfer office, and we do routinely file in foreign countries. In fact, Berkeley, the tech transfer office submitted a letter when there was the investigation of China under the Trump administration about challenges in licensing technology to China. But I think they're the exception rather than the rule. When I was in the patent office, I looked at, it was a very easy search to do, of U.S. patents where there was a Chinese collaborator resident in China with a U.S. co-inventor. So there are two or more named inventors, one resident in the U.S., could have been a Chinese national resident in the U.S. or an American, and a Chinese resident inventor. Most likely a Chinese national. Theoretically, it could have been someone else. And we also looked to see if there were, this was government-funded innovation. We also looked to see if there was any Chinese patents filed after the U.S. filing by the Chinese resident inventor. So we're trying to determine if the failure to file a Chinese patent might have been seized by the Chinese co-inventor to file a patent in his or her own name. No one had done that before. No one had done before. Because basically the budget for DOE or NSF or NIH is to file patents in the United States, full stop. And I think that's probably, I mean, you can go check the tech transfer office at Oklahoma University or Oklahoma City or some of the other schools around, and I bet you'll find that there's not much of a budget there for overseas filings, even if that is the dominant market. We need to be better. We need to be better about recognizing it's an international market. If someone goes ahead and steals your stuff because you didn't bother to protect it, it's questionable whether you should be blaming the party who stole it or yourself for not taking proper precautions. And unfortunately, I think some of our ways of doing things are pretty antiquated. Another example of this, by the way, is in licensing technology. With the exception of agriculture, if you were to walk into a US embassy today and say, I want to speak to the person in the Commerce Department who handles sales of US technology, you would leave a lot of people scratching their heads. The title does not exist. there's no one there who is tasked with not only transferring technology, but even trademarks or copyrights or franchises. It's technically complex, and we don't have the people on the ground who either have the legal skills or experience in how to manage a tech transfer operation. And this, frankly, to me, this impairs the effectiveness of our trade diplomacy, because we don't have people who are out there trying to promote legitimate, reasonable sales of technology that are in America's interest. So there's all sorts of ways where I think we could do a lot better. And China isn't stopping us. There's no one stopping us but ourselves in promoting technology and understanding where our value is, maximizing it, and protecting it as best we can.
Well, on that note of this need for an updated system here in the United States as well, if it is really serious about exporting competitiveness, forced nurturing and exporting that competitiveness, the US probably needs to do a lot more about its own IP system. And with that, I think we'll end this conversation. And thank you so much, Mark. And thank you, Professor Hsieh, for this stimulating discussion. I've learned a lot. I hope all our attendants have learned a lot. We have a lot of food for thought on the table, and certainly we hope to invite you back for another conversation in the future. Thank you so much again. I hope you enjoyed the discussion as well.
Thank you.
Absolutely. It was an honor and privilege and real pleasure to chat with Professor Cohen and Professor Kong, and thank you so much for inviting us.
All right. Bye-bye now.
Thank you. Bye-bye. Thank you.